This recording is to give you some context to help you as you start outlining civil procedure rules before the midterm. Civil procedure rules, unlike many of your first year classes, can be a bit challenging when you think about how to outline it. In part, it's because students either tend to miss the big picture and focus only on the rules, so they have a collection of individually numbered rules, and as we learn more and more rules, it's harder for you to keep them all in context and remember the sub pieces. So if you lose the big picture, you really get lost in all the rules and won't do very well. The other source of trouble for students is taking the opposite approach. By focusing only on the large picture, they often miss out on nuanced detail. It's important to understand, once you understand which portion of the big picture you're focusing on, that you can get into some real detail and find operative language of the rules. So here are some tips to help you. I think it's best first to focus on your goals for outlining. Your goal is not to create the perfect outline. If it were, then the best thing to do would be go to purchase an outline from the bookstore, download one, get one from your friends who've taken the class before you. Because if it's really about finding a nice one that's got all the right information in it, then that's easy to do, and it would be silly to try and create one yourself. But in actuality, what you're trying to do is give yourself that context, give yourself the big picture. What you should be focusing on, instead of getting an outline in the end, is thinking about these concepts. That's the whole point of the outline, to think about these concepts. The big picture of the process that you're learning. Where are you in the litigation? What are the overall goals of the parties in the litigation in this phase? And to also understand that more focused view, the detailed operation of each rule, so that you're not just stating with a lot of generality what should happen in that phase of the litigation. The other big goal for outlining is that it gives you a basic checklist, so that when you issue spot on an exam a particular concept, you have a clear approach for how to apply the rule to that fact pattern. Basically, your outline is your rule playbook that tells you, in this kind of context, what's the right judgment call, what's the right play to run. So how do you do this? Well, first, you want to focus on the big picture. All right, it's best to start with this before you start just diving into each individual rule and look at it discretely. So when you're looking at the big picture, you want to see the full landscape of the rules. So think about trying to create a one-page view of the course topics. An easy way to start is by organizing around the purpose of the rules you're looking at. What kind of purpose do these rules share in common? Could you break them up and group them together around common purposes? Or are there particular concepts that they all are relying on or all relating to? Thinking about this will actually help you issue spot. So far, what we've focused on is initiating a lawsuit and the ability for the plaintiff to initiate the lawsuit by filing a pleading, and the defendant to be able to respond to the initiation of the lawsuit in part by filing pleadings. We'll get to more options very shortly by the defendant, but that's our big picture concept right now. So you might want to think about it as, well, I've got pleadings, and I'm going to focus on the section of rules I'm learning because they relate to pleadings. And that way, later, when you get to more parts of the lawsuit and we have potentially new people joining the action, you can go back to the pleading section to be able to respond to questions of what they must do when they enter the lawsuit by filing pleadings. It's helpful to list the rules that apply to that purpose or concept together, just to get them organized so that you can start to see the connections between these rules. How do they relate together? Are all these rules required of every single person filing a pleading? Are there ways to sort of separate or subdivide from here? But what do they still have in common? What larger labels could I put here? So how do you figure this big picture out? Where do you start? What sources or resources could help you? Well, start first from the topic headings on the assignments and in the worksheet. The topic headings in the rules are also very helpful, but we've tried to organize the concepts in your worksheets around purposes for the rules or concepts of the rules. So if you start from the first several days of class, we had in the day 1 the scope and purpose of the rules and initiating a lawsuit. And under this large one-page view of the course, I might list rules 1 through 3. That way, when I decide I want to address a question, I could then jump into that section of my outline and look at the detailed rules under 1 to 3. But I just want to at least have some big picture analysis to see if I even need to rely on those rules to answer a question. The other topic we learned is pleadings, and you might have as big concepts a list of all the 7, the complaint with maybe 1 to 2 sentences there, or at least the list of rules that deal with complaints. We're going to talk more about answers in the next couple classes, and so you might want to have that as a big bullet point. But here again, what you're trying to do is just get the big chunks, the big bullet points, the big purposes, the big concepts. After you do this, we're going to move to the next step, which is diving a little bit deeper into detail. So you saw the big picture, but all of a sudden some objects are going to come into view, and you're going to want to look and be able to refine aspects of detail within those concepts. So for example, if we think about pleadings from our large one-page outline, we can take this down into a little bit more level of detail just in pleadings. All right, one important pleading we've spent a lot of time on are complaints. And essentially, these are pleadings that state claims. We'd also want to, in our little list here, say that the rules we've filed under our understanding of a complaint are also relevant to all pleadings that state claims. And so within this, what kind of large-scale, big block organization can we think of for complaints? Well, as we saw from the worksheet, and if you take literally the first couple pages of the worksheets, it breaks it into 1 and 2. Those actual numbers are broken out. You'll see the organization and format of a complaint, and you have some rules you could list, some sub-ideas, and secondly, content. So under organization and format of a complaint, we see Rule 10 that tells us about captions, numbered paragraphs, counts, adoption by reference. At this level, we're still just trying to get out larger concepts, or maybe our subtitles here. We're going to dig even deeper into each of these rules in a moment to show you the actual detailed look, but in this phase what you're trying to do is just give yourself maybe those second level bullet points of your outline. You still want to keep that one pager big picture off to the side. You don't want to get too much detail there, but as you're moving into the other parts of your understanding, you want to start fleshing out these details. So let's think about content. We learned about Rule 8A that's got 3 basic pieces to it: jurisdictional allegations, the statement of a claim, and the demand for relief. We also learned it in response to this, or in the same area, under 8D and E, and Rule 9, other aspects of content that you want and how to construe the content in these claims. So Rule 9 talked about the specificity we would need in our allegations. 8D and E refer to our inconsistencies and how to construe complaints. So that's one way, or how to construe claims. That's one way you could look at diving into a bit more detail. Beyond that, for those of you who are more visual, you might want to think about it as a flow chart, or here's a sort of a diagram way of looking at the exact same thing we just put in a linear outline. So consider what works best for you. So the same kind of content. Pleadings that state claims. Now I'm going to list in here complaints as being one of the examples of things I have that state claims. As a separate bubble, I might have format, and to list under it Rule 10, and I might list the caption, the counts, the numbering there. Another bubble, and because it has a lot of rules with it, I might put as the content basics, the 3 parts of 8A, and then the cases that I want to integrate to talk about 8A. I might have as a separate bubble just to consider if there's any kind of special pleading I need to give or any kind of specifics I need to allege under Rule 9, and another related concept, inconsistencies. Am I allowed to do that, and how do I construe the pleadings? Those things are listed by 8. So whether you're someone that likes the linear outline in Roman numerals as your header with each separate section advanced by an indentation, or you're someone who likes to think more like this in a flow flowchart or chart-based form. Really what you're doing at this level is trying to get just that. We're down from the big picture view, just the big bolded subpoints in this concept. And I would encourage you to try different approaches. Rules is a chance that sometimes something that worked in your torts class, your contracts class, say for example, might not actually work best for you in rules. So be creative and think outside the box and try and just explore some of these other opportunities to think about outlining in a different way. All right, so after we've gone to that first level of detail, we're going to get to even more detail. Things that are very tiny, like these little birds in our picture here, are starting to come into view, and we're going to really dig deep into the rules. So for students that have no problem seeing the big picture, their challenge often is finding the actual detail of the rules. In prior years, I've had students tell me, well, I didn't know we need to actually know any of the rule language. Well, it's important to understand key pieces of the rules. I'll talk in a moment about how much language you actually have to know. But for students that have problems with this, I find that they use just way too broad of brush strokes when they're talking about the rules. Almost like a generality, the summary of, well, in a complaint, you really need to make sure you state a claim kind of level of analysis. So if you have no trouble with the big picture, but this is your area, you want to make sure that you dive deep enough into the rules that you can actually understand their operation. So how do you do this? Well, you want to diagram the actual operation of the individual rules. So if we've seen so far of what we've gone through, we had that big picture view, our one page that we're not going to touch, we just have our big, large checklist. We moved into trying to find subdivisions of those larger grouped concepts, fleshing out maybe the big point headers, and we looked to our worksheets to help us find that. Now you're going to delve deeply into each individual rule. And watch out for the things that we've told you to watch out for, including who does this rule apply to? Are there any may or must language in this rule? In other words, is it an option to follow this particular aspect of the rule? Is it the discretion of the court or the parties? Or is it required, a mandatory obligation under the rule? Are there multiple pieces that all must be complied with? In other words, do we see an and separating a list of options? Or do we see ors separating our list of options? If it's ors, then they're not all required. We're also going to see, as we continue through the course, more rules that have a standard for the court to use or a test for the court to use to decide whether or not the parties have complied with the rule. And those things you're going to want to have in your diagram. Within this diagram, you're going to want to include a very brief summary of the cases that apply to a particular rule. So for example, if we were to start thinking about the diagram of the operation of individual Rule 8A, we'd want to have three separate small diagrams, one for jurisdiction, one for stating a claim, and one for the demand of relief. If we were to look at the second one, stating a claim that shows the pleader entitled to relief, we'd want to include the showing aspect of, and how that's been modified by the court in Twombly and Iqbal. And here, what you don't want is a whole case brief on these. What you really want is a standard and maybe a couple brief points, including maybe some of the hypos we did in class on those cases to illustrate whether or not the Iqbal standard would be met if you were given a new fact pattern. So you'd have the who, the may, must issues, the and or issues, and the standard for the court for 8A. And then in the statement of a claim, you'd want to include your summary of Iqbal and a couple of the hypos to show when those cases would demonstrate a pleading has satisfied stating a claim under 8A2 and when it hasn't. This is also a good time to include any definitional terms or include that in a master section. So for example, we've already defined things like pleadings that state a claim and pleadings that don't, pleadings to which a responsive pleading is required, and pleadings to which no responsive pleading is required. Those are terms that you'd want to either you want to have your definition of. In other words, which ones are the pleadings to which no responsive pleading is required, and which ones are the pleadings to which a responsive pleading is required. And sometimes we'll even give an actual definition of a word. You want to make sure you have that. And you can decide for yourself. Sometimes it's easier for students to have like a little pop-up box off the rule themselves here, like a little a chart or table. You can use the comment function if you're doing a Word document and add it in there, or sometimes it's helpful just to have a separate master section that you can refer to with those kinds of statements. That way when you get a new rule that uses a word like pleading to which no responsive pleading is required, you have the automatic place, you know where to go to find that definition. All right. The other thing you want to do when you're looking at this detailed view is to think about what is the triggering event. What is the moment that's going to make you want to look to this rule? What you don't want to do in a fact pattern or an exam is give us the kitchen sink answer where you're including all the rules that you've studied thus far. Now for the midterm, that's a problem just because you'll run out of time. But for the final, I mean, there's just no way you'll get even close to finishing the exam if you start talking about all the rules we've learned through the entire semester. So you want to think about what particular facts might get you to talk about this rule. And the way to do that is to both look back at the hypos that you have that illustrate your application of the rule. What is it about those hypos that make that rule called into question? Or think about the purpose of the rule. When would someone need to use this rule? What does it help clarify? Those kinds of things are the events you want to figure out to put into your outline. So for example, since we've been talking about AA2 here for a moment, what you want to do is think about, when would whether or not someone stated a claim properly be a triggering event. When would you need to think about 8A2 and all that's been said about it by the court? Well, it might be because someone's trying to themselves plead a claim and they need to think about, have I done this properly? Or it might be because the defendant is challenging whether they've in fact done that. Like for example, in a 12B6 motion, a motion to dismiss for failure to state a claim. Either of those triggering events will raise a discussion of 8A2. All right, so you want to think about it. A lawyer needs to use this rule if, or if I want to do these things, I need to use this rule. Or the court might question whether this rule has been met if, and all those triggering events need to appear in your outline. All right. Last, even getting more deep into the rules. How do you do this? Just a practical tip. Work up from your worksheet or just take a highlighter to it. Let's do one together. If we look at our Rule 9 annotated table in your worksheet where we talked about pleading generally, not having to plead anything, or pleading with some detail or denying with some detail. What you want to do is take those rules and dig into it. So we saw the table. Do I know what this says? Can I recognize it on an exam and can I apply it? How do I know what it says? So let's just take one example. In the annotated table, we saw special damages listed. And we see the rule. Special damages must be specifically stated. It means we have to have more detail for them. So, do I know that rule? Well, I'd want to focus on the key terms here that are important. Special damages, and they must be specifically stated. I need some detail when I plead a special damage. Could I recognize whether or not special damages come up on the exam? Well, let's think about the triggering event that would lead us to talk about whether or not this person has pled special damages appropriately. So I really need to know, what is a special damage? So we learned that it's something that wouldn't really be expected from the events. Either legally it's not the normal anticipated form of damage. There's something really unique about it that the opposing side would not be aware of. And we see an example. So here's adding in our hypo from the Chris the Rollerblader example from Miss Parsons. She had a very, very expensive violin that was destroyed during the collision. Now, while certainly personal injury in the form of physical injury and injury in the form of property damage would be something that would be expected from a collision with a car and a rollerblader, you probably would not automatically expect that the person would be carrying an extremely expensive, unique violin. And so that gives me a chance now to say, how would I recognize this? It's something that either the law doesn't typically, see for these kinds of claims, or something that was really unusual, and I would put my hypothetical in my outline, or at least a reference to it, so I have a triggering event to recognize it. So I know what the rule is. Special damages, plead with specifically stated language. I know how to recognize it. I've seen a hypo. And then lastly, can I apply the rule? So let's say I'm given on the exam a context in which someone states a special damage. Can I figure out whether or not what they've stated is specifically stated or whether it's stated with generalities? And so what I want to do is make sure I have hypos where I've seen general allegations, claims like in our Form 11, that talk about personal injury and property damage would be generally stated versus ones with specifically stated language. In other words, language referring either an amount or to the nature of the violin by its name, it's a Stradivarius, by how much it's worth. Those would be with more specificity as opposed to property damage. So now I have it. I worked for my worksheet. I found the table. I'm diving really deeply into Rule 9. Do I know what the actual rule is? I do. Can I recognize it? Yes, I've spotted a triggering event. I've given myself a hypo. And can I apply it? Yep. I want to make sure I actually understand more than just stating the words in the exam must be stated specifically. I know what specifically actually is. All right, some help for avoiding dangers. Don't do these missteps or you're going to be totally free falling. Here you go. Don't write the rules out verbatim in your outline. It's a huge waste of time, and it also isn't doing the thought process we've been talking about in this video, which is focusing on big picture, how do things relate together, seeing larger connections, being able to figure out where you're at in the lawsuit and why you might need to look to the group of rules you've grouped together. And also, by writing them out verbatim, you're not even doing the detail because you haven't even parsed out what the operative language is. You haven't said, oh, special damage is specifically stated. You're just writing it out verbatim. So a colossal waste of time, not doing any of the mental energy you really need to do, big picture and digging deep. What you rather should do is, instead of writing them out verbatim, use only the quotes of key terms or phrases. How do you figure this out? Well, in the worksheet, we've tried to highlight, often in bold or by asking you to apply things, the operational language. It's also the language we focused in on in class. So let's just take the example we just did in Rule 9. How would you know what the operative language is? Well, look to that chart on the worksheet. It says general allegations, allegations that need to be specifically denied or specifically stated, don't need to be stated at all. So clearly we know what we're talking about are general allegations and allegations with specificity or stated with particular aspects to them, and lastly ones that needed to be denied specifically. So all that language is the operational language, and the worksheet really guides you there. Okay, what else should you avoid? Do not outline according to the rule number. Now, while there's some help with the rule numbers in that they give you some organization, since the rules are organized in larger sections of titles, just sitting there and trying to work one by one through the rules as if 1 and 2 and 3 and 4 are all stated in a way that makes logical sense naturally to how you'd answer a question is just very misleading. They're not. Look to the way they're grouped together in the rule book, certainly for guidance, but stick with groupings. Groupings are the rules that we used in class. Groupings are the rules together as opposed to just going number by number by number. Okay, last tips when you're thinking about answering questions here. What do you need to know? The numbers of the rules, memorizing all the language, or just some? Well, as far as the numbers of the rules go, you just need to memorize the number and one letter after the number. So for example, Rule 8 and A, or as we get to after the midterm, Rule 11 and B. So we're going to learn, while we do learn subdivisions like 8A is a perfect example, we have 8A 1, 2, and 3. All you need to be able to tell us back on the exam is the number and the first letter. I do think when you're trying to write that big picture out, the second level down when you're trying to group subdivisions together, I showed you in 8A how it's helpful to at least recognize that there's 3 pieces to that. Sometimes students find it easier to know the next subdivision down. You don't get any extra points for that. It's not something I'm asking you to do, but you do need to have an understanding of what's in there. So this isn't a suggestion just to ignore how things are grouped or how they're subdivided even within a rule, but you just need to know the first number and the first letter. Also, don't memorize all the language. I just talked about that. Memorize the key terms. Organize them into a checklist that you can through those terms and have it applied. Focus on those provisions in a rule that we spend time on in class and that are highlighted by the worksheets. That's really how you can find the right language. And then lastly, and one of the most important things, in order to do well on these exams, you need to actually spend time working through hypotheticals. So your worksheets have given you multiple situations where you could do that, often in the context of a multiple choice question. But that doesn't mean you couldn't answer it if you thought about it as a short answer question. We'll also give you some more as we get closer to examination period. But all of the testing your understanding issues, all of the lawsuit action items are ones where you can try and see if your outline is providing you enough guidance to figure out what's important and what's not. So I hope you found this helpful as you think about working your way back to outlining here and thinking about the big picture along with the small detail.